Welcome back to Reunion. I hope you all had a terrific time last night. It was a wonderful event, I thought, both in the Torrey's Hall, and then I think we made it to about 8 of the 10 dinners that happened last night, and they seemed really convivial, fun occasions. So, welcome back. This is something that we had done historically, but haven't done more recently, which was to have something on the Saturday, more substantive. This is an experiment. I'm delighted to see you here. Before we begin, I want to acknowledge the land on which the University of Toronto operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and most recently, the Mississaugas of the Credit River. Today, this meeting place is still the home to many Indigenous people from across Turtle Island, and we're grateful to have the opportunity to work on this land. So, today's theme is the future of legal education and the profession, and we each have 15 minutes to describe an important part of the future, and you'll pretty well be well equipped to know exactly how everything's going to unfold at the end of this. So you're really getting value for your time. Our panelists today are Professors Ben Alarie to my left, Lisa Austin to his left, and Gillian Hadfield. I will speak as well to start things off. Ben is going to speak on law and artificial intelligence. A little about Ben. He holds the Osler Chair in Business Law and is the co-founder and CEO of a legal tech startup known as Blue Jay Legal, which uses artificial intelligence to provide legal research tools in the areas of tax and employment law, at least for now, probably a growing suite of areas. Lisa holds the chair at the Faculty in Law and Technology, is the co-founder of the IT3 Lab at the University of Toronto, which engages in interdisciplinary research on privacy and transparency. She has a status cross-appointment to engineering, which is itself, I think, a sign of the times that we have a law professor who spends a significant amount of time at engineering. Finally, I'm delighted to introduce Professor Gillian Hadfield. She's a professor who's cross-appointed here at Law and also has an appointment as a professor of strategic management at the Rotman School of Management. We are delighted to welcome her back to the faculty after many years south of the border. It's great to have her back. Her research is known the world round for its focus on kind of innovative design for legal and dispute resolution systems. She's working more and more on the governance of AI, has an affiliation with the Vector Institute here in Toronto to pursue that line of her research. So I will start things off by discussing the future of legal education. And what I'm going to do for my remarks is focus on some of the conversations that we had around a recent academic planning process at the faculty. But before I get to the future, I want to start with the past. And I'm going to go back to the founding of this law school. So for decades in Ontario, the profession was responsible for legal education, as many of you will know. Lawyers became lawyers by attending some lectures put on by experts at Osgoode Hall down the street, but they would more significant part of their transition to becoming a lawyer was through their apprenticeships. And so they'd work in offices as clerks and then go to lectures in the afternoon, that sort of thing. It was a system that was designed to produce a job-ready candidate, to use jargon that we often hear these days. But it was a system that was designed to use a job-ready candidate as ever there was one. Okay? But a few instructors in this program, Cecil Wright among them, Bora Laskin, future Chief Justice of Canada, another, John Willis, thought that this model was ill-conceived, that this was not preparing students, young lawyers, for a lifetime of success in the profession. They thought the appropriate place for legal education was to be embedded within a university. So in this famous, at least in these parts, act of rebellion, they came up the street from Osgoode and founded the modern Faculty of Law at the University of Toronto. It was not just a geographic move. The idea was to shift from an emphasis on sort of skills-based vocational training into broader intellectual inquiry into what the law is, how the law fits together, how to find the law, right? It was a departure from a focus on sort of black letter doctrine. This academic approach, to sum it up, an academic approach to a legal education is part of our DNA and continues to be a fundamental guide for us. And it's my view that this approach is as relevant today, perhaps even more relevant than it was then. So an academic legal education is sometimes, I think, misunderstood as abandoning or diminishing the professional mission associated with law school. And I think that's wrong. Teaching students how to think about law, coming at legal problems as we do today from a huge variety of interdisciplinary angles, makes students better problem solvers. It boosts their creativity, gives them better tools to break down problems through different lenses with different frameworks in mind. I say that not just because I happen to believe it, but I think the evidence is there. So as many of you will also know, this rebellion was not received well by the Law Society, and many obstacles were kind of thrown in the way of U of T Law School in its early days. So they tried to, it took an extra year to become qualified as a lawyer in Ontario as a consequence of coming to U of T rather than going through the Osgood system. Despite these obstacles, the early alumni and the early law school was a great success, right? So in the 1950s, the very small classes of the 50s produced Supreme Court justices, produced managing partners downtown, produced major business contributors. The success of our alumni, I think, reinforced the idea that underlay this academic approach to a legal education. I think it gave support to the idea that teaching people how to think is more fundamental than teaching them a particular rule. The rebellion at U of T spread, as you know, and now this is the model everywhere in Canada. The path to the legal profession goes through universities in every case. Now let me turn, so we're sort of up to the present. Let's think about the future. So we all know we're living in incredibly dynamic, innovative times, technologically and otherwise, too, actually. I think sometimes the change focuses too much on technology as opposed to other really interesting things that are going on in the profession, like the ascendance of in-house counsel, for example. Those have also had very disruptive effects on the status quo in practice. But there's been a question associated, especially with technological change, about whether we should sort of change our mission to focus more on the sort of skills-based learning that will be compatible with the kinds of technologies that lawyers will be using more, use now and will use even more in the future. I don't believe that this change that's all around us should shift our focus from teaching students how to think. That is, it should not shift from learning the laws of evidence to learning e-discovery software, right? Why do I say that? There's a few reasons. One, if legal technology is successful, it'll play one of two roles, at least in the near term. It's going to disintermediate some areas of practice, particularly disintermediate the kind of, what I might use the word, commodity legal work, sort of easily repeatable things. Those sorts of jobs are not going to be done by many lawyers. So teaching our students how to do some of those things that would be largely disintermediated through technology doesn't seem to be a sensible approach, especially, and this is an important point that doesn't generalize, with the talents of the students we have, right? There's going to be these tools that are going to be complementary to lawyers, but there's still going to be at the top, in some ways, those trusted, imaginative, wise counsel. That's where we see many of our students ending up, whatever their area of practice. And we think teaching them how to use sort of technology for some of the, less, I would put it, less creative areas of law would not be serving them well. One way, and another way to think about that is that, when we're teaching tax, this is one way to think about this problem. When we teach tax, ideally, we're not teaching you to memorize aspects of the tax code. Rather, we're trying to teach you about concepts that are embedded in our taxation system. Those concepts are going to last. The individual rules may change, just as actually technologies may change. If you learn the e-discovery software of today, it may change tomorrow. But if you have a fundamental understanding of the concepts within an area of law, those are going to be flexible and are going to last over time. A final point on this technology has never been more user-friendly, right? So I don't know if, Ben, you have a demo of BlueJay set up for us today, but if you ever, you'll talk about your website, I'm sure. It's incredibly easy to use. So I think spending a lot of time teaching, sort of more technical skills that are, going to be varying, as software will vary in short order, and will also be relatively easy to learn, is not a good use of time. Just as we don't teach students how to docket in law school, I don't think we should be teaching some of these more technical skills. Now, that all said, this doesn't mean that our entire environment is impervious to technological change. Most profoundly, technology is raising really interesting and new legal questions. Privacy, as we're going to hear from Professor Austin, privacy cannot be taught today like it was taught 30 years ago. It probably wasn't taught 30 years ago, in fact. But privacy is an incredibly important area of practice with all sorts of interesting problems, and we're delighted that Lisa is really one of the world's experts in the field to teach it. Right? Similarly, when we're thinking about the future of law, we have courses on artificial intelligence and the future of law. Ben teaches courses on that. A course on that. Gillian is teaching a course on legal design, getting students to rethink how our legal processes are designed and to come at legal systems as a design problem. So that may involve technology, it may not, but it involves innovation in any event, and we have to inculcate that in our students. So these are great ideas to be exploring. But the reason that we're exploring them is because they're great areas that raise great ideas to moot, not because we think there's a particular life skill or a particular kind of practice skill that they need to have as a consequence of that. Now, that's how our curriculum is changing. It's changing both in some of the courses we're offering. We have a professional master's program in law, innovation, and technology where we're focusing on some of the ways that law is going to evolve in the face of technology, exploring these interesting questions. But I also want to say that on another level, we appreciate that there are some skills that will be useful for our graduates. And what we've been trying to do with those particular kinds of much narrower kind of vocational skills is to locate them not in the classroom, displacing time with these fantastic people to my left, but rather situating them in a co-curricular way. So to build up the student's professional toolkit through co-curricular programming, extracurricular programs. It doesn't crowd out the ideas exploration that's the hallmark of this place, but still puts them in a better position to begin their careers when they do leave. So, and I said earlier that sometimes I think we get dazzled and in some ways understandably by the new technologies, but there's other skills that I think lawyers have for a long time lacked when they've graduated law school. One example is just a basic understanding of accounting. Whether you practice family, whether you practice corporate, whether you just are a sole proprietor running your own shop, some understanding of accounting is probably pretty useful in your practice. And so what we're doing there is we've partnered with Rotman, and there's a certificate, Rotman at Law certificate, that our students can get outside the credit system. They don't get credit for it, but they can get a certificate if they take an online course in accounting, which is the same online course that incoming MBA students get at Rotman, and also one in finance, and also one in statistics, all of which are skill sets which are transferable across areas of practice and indeed different jobs in and outside the profession. So that's one example of how we're trying to build up the co-curricular program. There's more that we can do in technology. This year we're really trying to build up a suite of alternatives around there. But also, this is another area where I think technology, at least not for a while, is not going to be disintermediating, and that is the kind of emotionally intelligent, wise counsel. And so we have something called the Leadership Skills Program, in which some of these other programs are situated. But the Leadership Skills Program is designed to help our students sort of learn their leadership style one way or the other and develop it. So there's courses, there's sessions, I should say, not courses, but there's sessions on things like emotional intelligence, professional communications, conflict management in the workplace, how to be an inclusive leader, lectures on unconscious bias, and the like. So there's lots that we can do. I just don't want to crowd out and interfere with what remains the kind of core mission of this law school, the mission that was its founding mission, which was to teach students how to think about law. So I'm going to stop there, and I'm next going to turn it over to my colleague Ben to speak about law and AI. Ben.
Right. Thanks, Ed. So law and AI is a huge, huge topic. I think what I will do is start off by explaining why I'm here talking about law and AI, give you a little bit about kind of the immediate past, how I found myself falling into this role of talking about and spending a massive amount of time thinking about law and artificial intelligence in the future of the profession as influenced by AI. And then what I'll do is I'll turn into a conversation around what is currently happening, what I see as I'm traveling and talking about law and AI, what's actually happening on the ground, what does the technology do now, and where should we expect it to go in the next few years? And then I will turn to talking about what does this mean for adjudication? What does this mean for the judiciary and resolving disputes in court? And then I'll back up a little bit. Okay, with that out of the way about adjudication, what does this mean for giving legal advice as a practical matter? If you're in practice, what does this mean going forward in terms of giving advice? And relatedly, a little bit, what does this mean for the law societies and others who exercise oversight over those who give legal advice? And I'm going to wind up with the topic that we're meant to really be anchoring this in, which is what does this mean for legal education? And then there are two dimensions to that, of course. What does it mean for faculty members like us and our research if AI is going to, in the most exaggerated fashion, kind of take over the law? What does it mean? And so there's an existential question. What does it mean for law faculty if an AI is able to really master the law? Do we have a role? Of course, the answer is yes. It has to be yes. What does it mean for our students at the law school? If we're still going to have law faculty teaching the law, what does it mean for students who are studying here? And I would argue, and I think there are echoes of how Ed opened this session, that this kind of legal education is going to be even more important going forward, not less important. And I'll explore that a little bit. So all of this started in the ways that are linked to the DNA of this law school, an interdisciplinary focus. I started as a law student here in the late 90s, and I studied, of course, at the law school. I did a graduate degree in economics alongside my law degree and picked up a lot of tools for analyzing different sets of data using econometrics, statistics, and that sort of analysis. I brought that to my work even as a law student. On that basis, I was hired as a tenure track faculty member. After spending a little bit of time at Yale, some time in Ottawa clerking, I came back, joined the faculty, and immediately set in on a research agenda focused on analyzing the influences that judges have on their decision making using a data-driven approach. So using statistical methods to try to unpack and understand what influences affect judges as they exercise their discretion in cases, as they're deciding cases, what patterns can we discern in that decision making? And so that consumed a lot of my scholarly attention for many years, resulted in a number of publications. What all of that research had in common is very interdisciplinary. It was very quantitative. It was all backward looking. So it was all retrospective. It was looking at historically how have judges exercised their discretion? What can we learn about that using different statistical methods? But around the end of 2014, I was serving as associate dean at the time. Around the end of 2014, I had this kind of subtle shift in thinking, which is what if we turned those statistical approaches around and tried to predict how judges would prospectively exercise their discretion? What if we use the same statistical methodologies to try to predict how judges are going to exercise their discretion? I became totally consumed by this idea, and it was all I could talk about to anyone, including two of my colleagues at the law school, Albert Yoon and Anthony Niblett. And I said, Anthony, Albert, what we should do is create a course. It should be an interdisciplinary course. We'll invite students from the computer science department who are doing amazing work with some of the faculty members there in computer science and artificial intelligence. Jeff Hinton, so there's some other luminaries AI and computer science or at the computer science department. I said, we can do this seminar. We'll invite computer science students to take it with us. We'll invite students from Rotman to do it. We'll invite law students to do this course. And what we'll see is how predictable we can get some software to be in a small area of law. So we started with one toy problem, and in January of 2015, we started meeting weekly. We created this ad hoc directed research seminar. And it was, we had several computer science students taking it, and the three of us showed up. We had a couple of instructors from the Department of Computer Science as well participating. And by the end of the semester, we had something that worked a little bit better than a coin at predicting how judges would exercise their discretion in new cases, just marginally better than a coin. But importantly, we had a long list of things that we wanted to try that we felt could actually make this system work a lot better in predicting how judges would decide new cases. So that was more than 3 years ago. Now, fast forward, so now that project, that academic project, became what is now Blue Jay Legal. And so Blue Jay Legal is a startup company that spun out of this academic exercise, and we're, the company's based here in Toronto. We're up to 30 employees. We have over 100 customers, 100 organizations, including small, medium, large law firms, accounting firms. The federal government is using our software to predict how judges are going to exercise their discretion in new tax situations, in new employment law situations. There are two products in the market right now. One is tax foresight, the other is employment foresight. Obviously, they provide guidance in those areas. What they have in common is that they exploit artificial intelligence, machine learning technology to basically figure out how judges are exercising their discretion across thousands of cases, and from the patterns implicit in those thousands of cases, figuring out what the best prediction would be about how a judge would decide a new case. And so using this technology, we're able to predict with 90% accuracy how judges are going to exercise their discretion. So just to give you an example, to make this a little bit more concrete, how it works is somebody would log into our system, and suppose your counsel and your client is a corporate defendant and has just been served with notice of a class action lawsuit being brought against your corporate client, saying, Uber, you claim your drivers are independent contractors. In fact, we think that all of your drivers are employees. Our representative plaintiff should be properly characterized as an employee for employment law purposes. This means that this worker should be able to lay claim to the protections afforded to workers under the Employment Standards Act, in addition to a bunch of other things, right? And so a lawyer might sit down and say, okay, this appears to be a fairly significant potential problem for my client. I'm going to log into the system, select the worker classifier, and the system starts asking the lawyer questions about the relevant scenario. So start asking the sorts of questions, the factual questions that would be the basis for a judicial judgment as to whether a particular worker or a class of workers should be properly characterized for legal purposes as employees on the one hand or independent contractors on the other hand. And the system is getting well over 90% of this particular question, the predictions right. We know that because we run a couple different ways of diagnosing the accuracy. One is we take all of the existing cases that have been decided, train the algorithms on 70% of the cases, and train up the model. There's a machine learning model underlying this. Train up the model on those 70% of the cases. Another 30% of the cases we hold in reserve as evaluation, and we suppress the results in those cases and present the facts in those cases to the algorithm. Say, predict what a court would do in these situations. The algorithm will produce a prediction, and then we can kind of compare with what a court actually did. And on that basis, we know it's getting over 90% of the cases right because it matches up with more than 90% of what courts actually did. The other way that we test it is as new cases are decided, and these cases are frequently decided, we compare the new cases as they come out with the predictions of the model. And so as new cases are decided, we're getting more than 90% of the cases right. So this compares very favorably with a coin on the one hand, right? But even with lawyers exercising their discretion. So if you give a group of lawyers these fact situations that are typically fairly ambiguous, right? There are always things that point in one direction and things that point in another direction. It's difficult to know exactly how courts are exercising their discretion when you have kind of mixed indicators in any given case. And so this is what we spend a lot of time at the law school training our students to do, right? To, like, on the one hand, on the other hand, and then you go a layer deeper. Well, there are caveats to this, caveats to that, and then ultimately we kind of force students to give their prediction on an exam. Like, law is a prediction exercise for the most part. Lawyers are not, except for those who really specialize in a particular area, not able to get to the same level of accuracy as these algorithms. Okay, so what does this mean very quickly? Priscilla told me I just have 5 minutes left. I'm like, I'm just getting started here. No need. I'm just going to hit the highlights. So what does this mean for adjudication, right? You might say, well, 90% is pretty good. If you're at 90%, does this mean like the end of judges as we know it? Absolutely not, because as these tools make their way out into practice and into government and even into in-house settings, what it means is the no-brainer cases are going to be recognized as no-brainer cases, and they're going to settle. Right? So if there's no real prospect of reaching a different outcome in court, nobody's going to invest in taking it to court, and you're going to settle it. So that's great for clients. They're going to settle the ones that ought to be settled. It also means the cases that are left on the docket at court are going to be the more challenging cases, right? So they're going to be in that indeterminate range. This is, by the way, how the law is supposed to work. We're supposed to have judges deciding the more difficult cases and kind of zooming in on that area of legal indeterminacy. And then those results actually get turned out and become part of the additional training set to train these algorithms to improve the clarity and transparency of the law. So judges are left looking at this more indeterminate set of cases, exercising their discretion. I fully expect their law clerks to be making use of these artificially intelligent tools in getting a lay of the land and being self-aware about the extent to which they're nudging the law in a different direction. If they're taking the minority view in one of these cases, it'll basically prompt them to give it some thought. And why am I moving the law in this direction? What makes this case different? Is it social changes, economic changes, political changes, technological changes? Something's changing in the background, and that's why we're going to nudge the law in this direction. So judging, paradoxically, actually becomes more difficult in the presence of AI in the legal system going forward. Now, what about legal advice? Lawyers often say, oh, this is really scary. What if I use an AI system to inform my advice and I'm wrong? I'm feeling kind of exposed by the prospect of using some of these technologies. What if I use it and it turns out and I'm in part relying on the AI and I'm wrong? And then I think the immediate counter question has to be, well, what if you don't use it and you're wrong, and had you used it, you would have been right? Because that's the more likely outcome. So you can fasten on to the worst case scenario. I use it and I rely in part on it and I'm wrong. Actually, the more likely thing that's going to happen is if you don't use it, you're more likely to be wrong. And so there's going to be an interesting thing that's going to happen at the law society level. And at what point do we collectively as a profession want to insist that if you're giving particular kinds of legal advice, you at least need to run it through a technological system to make sure that you're not missing anything really important or obvious. And if you are, of course you can give legal advice inconsistent with what an algorithm is saying, but you need to explain why. There should be some accountability. Why are you giving a self-serving tax opinion to that client who wants to know that this tax shelter is going to not be subject to the general anti-avoidance rule? If the algorithm is saying that there's a 95% plus chance this is going to be subject to the general anti-avoidance rule. Legal education, the most important piece. What does this mean for law faculty, law students? It's a similar story as it is for judges, right? Things actually become more challenging, more difficult. These algorithms are great at predicting as a positive matter what would likely happen in court, but they're, at least for the time being, not capable of giving a normative answer. What should the law be on this particular question? It can say, well, based on all the prior cases and how they've been judicially treated, the best prediction is that a judge would say X or Y, but it's not able to say, for, for these normative reasons, or indulging this normative principle, and the contest of these normative principles, it should go one way or the other. So that remains the domain of the human. Humans are going to be in the loop in the legal system, I think, indefinitely going forward. So this is not about replacing humans or taking humans out. This is how do we exploit technology to do a better job of analyzing the law. And I like to put it this way. I think about artificial intelligence as saving the world from shitty legal advice, is how I kind of think about it, because that's really what it's all about. And so, if you're at all questioning which way I stand on whether AI is a good thing for the profession and for the law, I think absolutely it's a good thing. It doesn't mean it's not without its risks, of course. And so I think keeping humans in the loop is a big part of how we protect against the worst possible outcomes, and also secure the greatest possible benefit from using this technology. Thanks.
Great. Lisa.
Thanks, and thanks for inviting me to this panel. What I thought I'd do is talk a little bit about some of the research I'm involved in right now, that's sort of collaborating with folks in engineering and computer science, and explain a little bit about why I'm doing that. I'm kind of an unlikely person to do it in some ways. I'm trained as a philosopher, not just a lawyer, and although I'm cross-appointed to engineering now, I have no background whatsoever there. So why am I working in this space? And I thought I'd just tell you a little bit about that generally, describe briefly a couple projects to give you a sense of kind of what types of things we're doing, and then make a few general reflections on what that might mean for legal education or the profession. So as Ed mentioned, I recently sort of co-founded a research lab here at U of T with a computer engineer named David Lee, and our lab is called the IT3 Lab, Information Technology, Transparency and Transformation. So it's really playing on a lot of themes around transparency, which we think involves privacy too, because it's how we're becoming transparent to others, and usually involves various privacy issues. So what we're trying to do in this lab, it's interesting when I talk to people in law and I say, oh, I've sort of been part of this new lab and we're doing this interdisciplinary research, they say, oh, that's great because you're a lawyer and a philosopher, so you must be there talking to these folks about how to make their systems more ethical, right? They need this ethical training, they need values, we need privacy by design, so that's what you're doing. And I say, well, that might be true, I don't know, that's not what we're doing actually. I feel like I'm there learning more than sort of colonizing their space. And what we're trying to do in our work is to find projects that are really deeply collaborative, where we learn from each other, and that change both in terms of how we might think of designing systems, but also how we think about how we regulate, and not just kind of the nuts and bolts of regulation, but even how, what kinds of values are at stake in the regulation, and how we go about doing that. So it's very much a two-way street. It's very much a deeply kind of collaborative space. So what do some of these projects look like? Well, one of the ones that we're doing right now that we've been doing for a little while is around lawful access. So lawful access, as many of you probably know, is just kind of the shorthand words that we use for when the police get access to, say, communications data. That's what we're interested in. Under what terms, right? What are the warrant requirements? What are the sort of authorities that are used in that context? And so we're very interested in some of these debates, and in Canada, there's been a lot of debates going on around communications metadata, so the data about your communications, not the content of your email, but maybe like who you sent it to, or how long it was, or where it came from, or where it went, or even more basically things like subscriber information. Who holds that account? Can you trace back to, you have someone downloading something from an internet address, can we figure out who that person is? And the way it's gone in law is to use categories of information, this kind of metadata, and to lower the constitutional standards under which people can get, the law enforcement can get access to that. And so it's very much a kind of plays out as a normative debate between, is it really private, is it not private? If it's only sort of private, we can lower the constitutional standards and give access to it under a much lower set of thresholds and protective measures. And a couple couple of years ago, I was at a meeting that was trying to deal with the follow-on of a Supreme Court of Canada decision called the Spencer decision. And in the Spencer decision, the Supreme Court kind of blew up this strategy that had been going forward by saying that you need a warrant to get access to basic subscriber information. The federal government had been proceeding on the theory for years that this wasn't really all that private and that you should be able to get warrantless access to it. And so the Supreme Court kind of blew that up and said unanimously, reasonable expectation of privacy, you need to get a warrant. And so then the response was, how do we legislate around that? And so I was at a stakeholder meeting where there was a kind of proposal being floated about how to legislate around that. And it was just a big fight. And it was interesting because I was sitting there thinking, my God, we haven't moved forward in 15 years. We're having the same fight. And again, is it private? Is it not private? And I sat there because I'd been talking with my collaborator in engineering, David, for ages about different sorts of projects, but it changed the way I started thinking about things, and I thought, there's got to be a better way forward. There's got to be some kind of different solution space here where we can suspend that disagreement and kind of move forward in a different way. And so we convened a team. We convened a team of people in computer science, computer engineering, and law, and said, okay, what you got in your toolkit? And we sort of had this massive, intense brainstorming session over several days. And it turns out there's lots of really interesting research in computer science and computer engineering where you can do all sorts of really cool things that could allow the police to do some of the things they're saying they want to do without doing the things that we're worried about, which is lowering constitutional standards. You can do all sorts of really interesting things like computations on encrypted data and things like that. So we started exploring that research and coming up with what we thought were interesting protocols that were a way around this debate that was at loggerheads, and we thought this was really interesting. So we have some spin-off projects of this. We're sort of writing about it and hoping to, we've been workshopping some of it and hoping to publish it, but we've also started talking to the police. So we've had a series of meetings with the Vancouver police. They're still talking to us, which is a good sign. And we've been reaching out to the Toronto police to say, will you talk to us? We know we disagree on all sorts of things, or at least some of our team. We have a very diverse team, which has its own challenges, but we don't have to agree on a whole bunch of things, but maybe there's some solution space in the middle that we're not seeing because we're so used to looking at it in a particular way. Will you sit down with us? And in fact, we can build you something and you could try it and we could learn together in doing that. And so I don't know if that's going to pan out. I hope it will. They haven't said no yet, so I take it that as a sort of positive. So another project that we're doing, and we had some media coverage for before too, which itself is kind of a funny story, which I'll tell you, but is a project that David started with some of his graduate students. So they built this really interesting tool. And it was originally a tool to get rid of lawyers, actually. So what it does is it takes your app on an Android phone. Sorry, I have an iPhone here. And what it can do is it can scan that mobile app, and it can learn about what kind of data collection practices it has through the permissions. So things like device ID, location information, is it accessing your contacts, stuff like that. So it can figure out if it's getting access to that data. It can figure out if it's sending it off the device. And we analyze a whole bunch of privacy policies using machine learning to categorize and analyze those policies so that you could map it against those data practices and automatically say, is it collecting data and is it declaring it in the privacy policy, or do we have undeclared data collection? So they built this tool, and originally when David asked for my help on this, it was pitched as, engineers don't like talking to lawyers, so I'm going to build this tool and then I can reverse it so that app developers can just automatically create a privacy policy and then we don't have to talk to you lawyers anymore. So that's kind of how we started working together. And I said to him, well, actually it's a pretty cool regulatory tool because you can now take that and examine the mobile app world at scales that the regulators can't do. And he said, well, how do regulators do it now? And I said, well, it's an individual complaints model. So a consumer has to figure out there's a problem. They have to go and make a complaint. The privacy commissioner or one of the provincial privacy commissioners has to decide to investigate. And then they've got all these investigative powers and they can go figure out what's going on. And he just stared at me aghast, like, that's so not scalable, and how are you going to do this? Like, there's thousands of these that go on the market every single day, like every single day, right? The scope of this is kind of staggering. So I said, okay, this is a really cool regulatory tool. So we built it as a regulatory tool, and now it worked. Which I shouldn't sound so surprised. I'm a bit of a Luddite sometimes, but I'm like, wow, it's cool, it really works. So that was the prototype, and now we're actually talking with some of the regulators to say, you know, will you sit down with us, and can we build this for you for real, and will you use it, and can we then iterate and test it out? And those talks too are going well and will probably happen. The funny story about the mobile app project was that, so I'm the one who's like writing the reports, and they're the ones building the stuff. And as I was writing the report, trying to sort of, you know, analyze what had been done, the last bit of information that they sent to me, the last bit, like 2 days before I had to submit this interim report, was what happened when they ran this tool on 800 apps that they had to see what would happen as a test. And they had never told me what the results were. So you know, it's like Saturday morning, I got my coffee, my sweatpants, and I'm like opening this file. And they found a 60% non-compliance rate. Like 60% of the apps they tested had undeclared data practices, which, you know, I'm like falling off my chair and started sending out, you know, emails and messages going like, this is kind of interesting. And the response was, yeah, from a policy perspective, I suppose it is an interesting finding. I'm like, it's like way more interesting than that. So, this was at the time of the Cambridge Analytica scandal, which is all about, you know, opening these platforms to third parties and get people getting access to your data. And what the problem with the 60% non-compliance rate was, 80% of the problem in that space was the use of third parties. So if you're going to monetize your app, you probably want to put advertising on it, and the way you do it is you use what they call an ad library. So it's just a piece of software from somebody else. So it's third-party software that gets plunked in by the software developer. Same with analytics. You want to figure out how someone's using your app. They put an analytic library in. So basically, there was this huge set of problems where third-party advertisers and analytic libraries are being used in apps and not being declared in the privacy policy. So we thought this was really interesting. And so I said, you know, it's not just interesting to regulators and lawyers, it's interesting generally, and we actually had some media, like the CBC reported on it. They agreed it was interesting too. But you know, my tech team, it was like the last thing they were thinking about when they were doing this project. It was kind of an afterthought in terms of the findings. So that was kind of fun. Anyway, so that's ongoing as well, and we have a number of other projects. I'll just close with kind of some reflections on like, what does this mean for legal education and the profession in terms of the general theme for the panel. It certainly affected a lot of how I'm thinking about teaching, and certainly when I speak to professional audiences, I get a lot of people coming up to me afterwards saying, so how do you find people to talk to in sort of, you know, this technology space, because my job is requiring me to sort of learn more about this as well, certainly when you talk to people who are doing things in the privacy space. And I think that, you know, I would have thought a couple years ago that really, you know, I would have needed more sort of technical know-how. I would have needed to learn a lot more. I have learned a lot, actually, about things like Android operating systems. But that has been the easy part, to be honest, because you don't need to know a ton. The hard part and the more interesting part is the group work part. I mean, lawyers are kind of solitary, at least in my experience. Legal academics tend to be kind of solitary. Philosophers are totally solitary. So working in a team is a new thing, and working in a team across this vast chasm in terms of professional backgrounds is really challenging. So we've had really strange conversations where we've been talking for 15 minutes, and it's like, I thought we were agreeing, and I think we're not even on the same page because we're using the same words in like remarkably different ways. These are basic words, like data, privacy, like really simple things, and because it comes with so much professional baggage in our own spaces, we didn't even clue into that till we're well into a conversation and realizing we're just kind of not actually meeting up. So that's really interesting, and understanding the need for there's a lot of trust and a lot of just kind of emotional intelligence in sort of managing a space like that, because you have to trust other people that they know what they're doing. You have to be willing to say, I don't know and I don't understand and you need to explain that to me. I say a lot of I don't know, even about things that I'm supposed to be the expert about these days too. And if you can't do that, you can't actually come up with new ideas. And so that's an interesting thing, as well as doing that in a way where everyone feels okay, but is still ready to say, that's a really dumb idea and we can't do that. So it's interesting to manage all of that together and manage really diverse teams that have very different commitments politically and normatively as well. And that surprised me. It's fun, but that's the part that has surprised me, and I think that is a space for us to think more about how to build those competencies in our students.
Thank you, Lisa. Gillian,
Okay, I'm going to actually use a bit of tech here, so
this mic probably is working.
I think so. All right, you were going to come switch this over for me, thanks. All right. Okay, great. So I'm really delighted to be back at U of T, as Ed mentioned, after 18 years in California and more. Among the many reasons I'm very glad to be back in Toronto, working with, of course, Ed, but Ben and Lisa, because what I'm really interested in is how are we going to reinvent law to manage a really complex world, a very, very different world from the world in the 20th century that we developed all this stuff in. And both Ben and Lisa are talking about really creative new things that they're creating. And I want to talk a little bit about whether or not, how our legal regulation, our approaches to law, things well developed through the 20th century, are they preventing the emergence of some of these new technologies that could benefit? So the use of AI in law to improve access or improve the ability of law to provide guidance to corporations. Is our approach to law and legal regulation interfering with the development of great solutions like what Lisa's talking about with privacy? And my answer is going to be very simple, yes. This is especially so, it's so across the board, it's across the board from the large corporations, it's especially true for ordinary people and smaller businesses. So I've become a bit of a evangelist on these topics, so I'm sorry you're going to get exposed to a little evangelism here. So let me just, the basic question, why? How are our approaches to law and legal regulation getting in the way? So I'm going to talk about two things. I'm going to talk first about what Ben talked about, which is about the use of technology to do law, in law, legal services. And then I will get to the development of law, the use of law by technology. But let's focus on the use of technology in law. And Ben talked about the emerging role for artificial intelligence as a component of the delivery of legal work and legal help. Ben emphasized the legal research component, or that component of predicting what it is, what have the cases done, what will the judges do, a really important part of what lawyers currently do. But he also mentioned that we could also be using artificial intelligence to craft legal advice, because it's not just a prediction about what a court's going to do. It's, okay, given the way the law will treat this, how should you design your company? How should you manage? What should you put in the contract, the severance agreement? What organization should you build? What formal structure should you use given the tax treatment and so on? There's legal advice about how to behave. But there's also the use of artificial intelligence that's emerging. It's either in development now, it's on the horizon, using artificial intelligence to, for example, figure out, does somebody have a claim? There's a terrific exercise going on between Suffolk Law School and Stanford Law School right now, crowdsourcing the descriptions that ordinary people use about their problems to say, can we identify whether there's legally relevant claims being made here in the ordinary way in which somebody would talk to Alexa, for example, or what they would enter into Google. We're building artificial intelligence to assist in the actual filing of claims. Some of it is, to my mind, is a little plonkety-plonk. It's sort of like, yeah, you can hit a button on a chat bot and you can contest your parking ticket, you can file your claim. That's all you can do. You're not getting any help figuring out if it's a good claim or what you should do with it, but you're getting that. There are people starting to talk about using artificial intelligence in the deciding of disputes. So AI judges, which sounds awful, except if you take into account that 80 to 90% of people never get the benefit of any kind of formal assessment of their claim, so that for some people this may be in fact an improvement on where they are now. AI being used to draft documents and interpret documents. So lots of really great value that is out there. But for those really innovative uses of technology to emerge, they need different business models than we currently have in place for legal services. These are the kinds of things that take investment. They take investment dollars. They take engineering brains. They take business design brains. To be innovative in that way, it requires different business models than the ones which we have in place as a consequence of the way in which we regulate the legal profession. So one of the things I emphasize, I'm also an economist, as Ben mentioned he is, legal regulation, the rules we have in place about how we decide who can be a lawyer, who can provide legal services, what kind of a practice you have to have, where you can take investment money for that practice. A large component of that, a significant part is ethical, but a large component is economic regulation. It is making an economic determination about how these businesses can be structured, about who can provide legal services, who can invest in legal services, who can invent legal technologies, how legal services are paid for, how they're financed, and how the incentives, therefore, for creation are secured. So the rules we have governing who can provide legal services are having that impact on the business model and therefore on the extent to which we're actually getting this stuff. Ben has a very nice cushy job. I'm sure he's got a business that will pay off, but that's a part of how that can develop. It's a way in which it's being financed. Our traditional approaches to legal services, our processes of licensing, they presume and they bake in traditional lawyering. Again, that's worked extremely well through the 20th century. It's wonderful. We license lawyers. And what that means, and you can sort of, the way we license, we assume it's going to be a person providing those services as a professional. So with our educational requirements, our bar passage requirements, moral character, articling, those are things you need people for. And that means that tech companies can't become authorized providers because there's no way for them to go to law school. There's no way for them to take the bar. I do actually think that, I don't know whether, I was down talking to the people at Ross recently saying, could Ross pass the bar? It's possible Ross could pass the bar. But can't become an authorized provider, can't take the bar, can't go to law school. But it goes further than this. It goes further than simply saying we don't have a regulatory structure in place that allows entities to become providers. We also have rules in place that say tech companies can't partner with or hire authorized providers because we can't have fee division between lawyers and the company, and you can't have the company providing services to the public even through employed lawyers on staff. An employed lawyer can provide services to their employer, and that's all. So this is my first evangelistic. Here's my message here. What do we need to do? First of all, we need to create an entity regulation regime. We need to develop the regime that can regulate organizations, companies that provide legal services, and not just people. Otherwise, we're baking in that business model. So we need to develop that regulation system that can handle that. We have to change the meaning, the salience of these words, the sentiment of these words of the corporate practice of law. It's a good thing. We should like it. We now have the corporate practice of medicine. It's a good thing. And we should figure out how to allow fee divisions. And all of this, by the way, goes back to the first question was how do you design that regulatory structure for law? It is not simply an open field, throw it out there for tech companies. We need that, those entity regulations. That's one of the things that I'm working on to develop a prototype for that. Okay, so now let's move to the use of law by technology. And I flashed up at the beginning, I failed to draw close attention to my book, Rules for a Flat World, which is motivated primarily by this question of saying, what is the impact of the way in which we're doing law, the approaches we use, the way we license lawyers, the education that we provide, how we develop our legal rules, what's the impact of that on the capacity to support the dramatic changes we're seeing in the economies, globalization, digitization, and so on. So Lisa talked a lot about privacy. There's a lot of things that come into play here as we think about how are we going to imagine this world that is exploding with the creation of data and the extent to which information about us and our activities and so on is out there in digital form, flying around the world. I teach a course on responsible AI over at the business school to management analytics students, and one of the things that we study there is, you think anonymized data is anonymous? No. As long as there's a little bit of other stuff out there in the world that somebody who wants to re-identify that data, a lot of it can be re-identified. But what are the issues that we're seeing in this realm of privacy and more generally information governance? We're seeing issues around, Lisa's emphasizes a really interesting and important problem of what's actually, are the apps actually doing what they're doing, they say they're doing? Well, we know we have those long, extensive privacy policies and the terms of service that we click on a constant basis. Nobody reads them, nobody could read them. If you did read them, you wouldn't necessarily know. But guess what? You need the AI tools to even tell you that what's actually happening with the data does not line up with the document. With these tremendous obstacles to this technique we continue to use of contract, but it's really not an instance of contracting. How is it a contract when when the person who's click really doesn't understand what's in there? We have things flying across multiple jurisdictions, but our legal systems are designed largely around coherent, nationally based legal institutions. The data is everywhere. We have big questions about who owns the data. We know with the GDPR, we've got claims about who, you own your data, but what does that mean when it's integrated into an algorithm? What does it mean when it's in a little tiny bit that's been plopped down in those third-party apps? How are we going to rethink our approaches on trade secret, for example, because we're seeing the emergence of tremendous inequality between the entities that have and process the data and the rest of us. We have privacy protections for the rest of us, and we have routine, not even heavily examined trade secret principles applied to the protection of data within the organization. We're seeing, of course, the increase in complexity, inequality, and speed. And it's not just about privacy, it's about data generally. So how well is our existing legal infrastructure meeting that new demand? My answer is pretty straightforward, not very well at all. There was a KPMG study, 2012, asked global executives, they asked them, what's the number one problem you face? Complexity. What's the number one source of complexity? And on a list of 10 things, 7 of them are law, and the number 1 is regulation. Number 3 is government oversight, which I thought was the same thing as regulation. But anyway, they're all the same. We're seeing a world of tremendous regulatory lags. Lisa's partly describing for us, it's a long catch-up. What are we going to do? Are we going to have 3 years of hearings? Everything has moved ahead by the time you've had 3 years of hearings and created law. Regulatory resource constraints. It required that investment from computer scientists, people totally outside of our existing environments, to develop those regulatory solutions. And we have most of our regulatory invention happening within public entities. Public entities have a very important role to play in regulation, but they're not sources of great innovation. And so we're seeing regulatory failure. So my view is that we can't actually continue to regulate legislating rules in our conventional ways. We need to come up with new models, new regulatory technologies, a concept that is now starting to bounce around of agile governance. I'm on the World Economic Forum's Council on Agile Governance to try and develop some of the tools for this. I think we're going to need AI to regulate AI and to develop global regulatory capacity. So I've been looking at how we can recruit the innovativeness of markets to the problem of building better rules. I have this proposal around what the concept that I call super regulation, which is taking advantage of the fact there are already lots and lots of private entities in the regulatory business, lots of private standard setting bodies, for example. They are actually the ones who are now out there funded by companies building the rules for AI ethics, for privacy, for digital security, and so on. And I think what we need to do is think about how to build those in a way that actually brings them under the umbrella of government more, So this is our existing model of government. We have governments that we serve, it's a schema. Governments that generally come up with command and control regulation for our entities. And this proposal is really to insert a layer of, we've got our private regulators, but to bring them under the oversight of governments by establishing outcomes that our private regulators are held to achieve. For example, how much data is getting exposed, right? That might be an outcome that we impose on the regulators, and then have regulators who are providing in a market regulatory services to our regulated entities. The reason for that is those dollar signs down there. That's pulling in the resources to invest in the fundamental problem of how can we invent better technologies. We have to figure out how to increase the rate at which we can invent, the capacity to invent solutions that, frankly, people like us don't reinvent. We sit around, we think of rules, we write them down on paper, we have committee meetings, we hold hearings. The engineers sit around and say, how do I build that? How do I build that algorithm? Right? Or the organizational psychologists think about, how could I restructure the way we do this to reduce the amount of conflict so we don't have so many employment disputes to deal with, right? So we're going to have to build that innovativeness. And I think it's really quite important. This is the evangelizing part. I really do think these are threats to the continuation of peaceful, inclusive, and safe societies. And it's the right thing to do. Thanks.
Thank you, Gillian. Wonderful. Thank you to all our panelists. There is time for questions. There are handheld mics, which might be great if you have a question to walk to one of the microphones to ask it, in part because we're recording it, in part because the acoustics in this room benefit from mics. So if anybody would like to start? It's a small crowd, so there's a lot of pressure on each of you now to be thinking hard of the questions. Sure?
So what happens if someone uses a Blue Jay legal tool and the right answer falls into that 5% that the algorithm doesn't get, and the advice is wrong? Is it the lawyer who's liable? Is it you who's liable? Is it both, or what happens?
Liable to who, Luciana? I guess is the question. So who would be filing the claim? I mean, the very legalistic answer is there are disclaimers all over this thing saying this is 100% not legal advice. This is a legal research tool where you can,
So not banned.
you can get a sense of, but I mean, so who would offer a guarantee that they're legal? So which law firm? Show me the law firm that says, what we're going to guarantee the results of the opinion that we're giving to you. And by the way, the opinion has zero marginal cost, right? Because that's kind of how you're using it. This is how our users use the software. So they log in, they can run scenarios and run unlimited scenarios, kind of test different possibilities. It's a way of understanding kind of the hidden topology of which facts are really salient, which are germane, which are really moving the needle in terms of how the judges are analyzing these cases. And so you can kind of get unlimited insight from using the tool and running all these different scenarios through the tool. The tool does tell you its level of confidence. So based on the decided pattern of cases, this is what we'd expect to see. This is what the algorithm would expect. But it's very clear this is not legal advice, and it's totally consistent with the model, which is you can use this thing and get as much potential insight from it as you'd like. There is a way in which this kind of technology develops, though, which is very interesting. And Gillian, some of what you said was interesting and kind of prompted some of these thoughts for me, which is you could easily imagine this kind of technology developing in this direction, which is to say you get to the end and says there's a 95% probability that a court would decide this set of facts in this way. Would you like to guarantee that result? If you would, you can pay this premium. It's X dollars. How much coverage do you need? And you can buy coverage to guarantee that result. So much like when you do a land transaction now, you'll often buy title insurance, and title insurance is less than the cost of a survey, so you would never send out a surveyor to actually go and do that work, because you just buy the title insurance and you're better off doing that. There's a way in which legal risk can be transformed into financial risk and just harness market forces to actually solve it using financial technology. And that may be a better solution. Some of what you were talking about, Gillian, it kind of struck me that you're saying, oh, what we need to do, so suppose we have this regulation that only land surveyors, registered land surveyors can survey property. Some of the suggestions about what we should do in the legal profession is, we should be able to have like corporate surveyors, we should be licensed drones to do like proper surveys. And my reaction is, well, those are interesting ideas, maybe that's the way to go. Or maybe the way to go is just to say, actually, you don't need a survey. There's another way to do this, which is just to put a price on that risk and maybe figure out who the best positioned party to bear that risk is and have them bear the risk. So this would be another way of responding to the desire to make someone responsible for an adverse outcome, which is to say, well, we'd be happy to be responsible for it because we have great information about what the chances are that things go wrong in this circumstance. And you can offload that risk. We'll own that monkey. You can put it on our back, but it's not free. It's gonna cost a little bit. So I think that's where this tends to go in the future, because we'll have better information about what these legal risks look like.
Great.
Just another question on the software. So just as a sort of first question, what sorts of things beyond sort of the general anti-avoidance provision in the Income Tax Act and independent contractor does your software sort of predict? And number two, so obviously you tell the software the facts. And as I'm sure everyone is aware, at trial a judge has to make findings of fact sometimes. So does the algorithm hedge itself on the uncertainty of findings of fact, or does it just assume the facts are correct that are given to it?
Okay, yeah, so two-part question. The answer to the first question is what else does it? It does a lot of things. So it addresses 26 different frequently litigated issues in tax law, and then the employment law product canvasses a dozen different issues that are frequently litigated in the employment law context. Some of the big ones are like, is something on account of income, or is it on account of capital? Is something a windfall, or is it actually business income? Is something deductible as a current expense, or is it a capital expenditure? They're big kind of organizing conceptual ideas that the Act can't address in detail because they're kind of high-level principles. The Act is very finely drafted, right? And they're very well-elaborated rules to deal with things once you know what they are. So a lot of the most frequently litigated things in the tax context are actually high-level, is this a this or a that kind of question? And so that's what the software focuses on, these orienting questions, because once you know whether something's an apple or an orange, kind of which part of the Act you're dealing with, and a lot of the results kind of flow through. And so it deals with those high-level kind of conceptual sorts of characterization sorts of questions. They're also the sorts of things that get litigated a lot and often are the most consequential from a tax perspective, just in terms of the dollars at stake. Does the general anti-avoidance rule apply? This is a huge question with a lot of economic significance. With respect to the question about the facts, of course. So one of the big use cases of the software is to understand which facts really matter. So if you're in a potential tax litigation context, it is really nice to know which facts you really need to bolster and support in the evidence versus which ones actually are immaterial to the outcome. One of the interesting things that we learned in building the software is that there are tons of cases that end up going to the court, the tax court, federal court of appeal, where the outcome, especially at trial, you'll get, well, one party alleges these are the facts, the other party, had these witnesses testifying that these facts were the better view of the situation, and the judge then makes a set of findings of fact, kind of selecting as between the parties and constructing a narrative about what actually happened in those circumstances. In many of those cases, regardless of which version of the events you run through the software, you get to the same overall legal results. So these are cases that actually have no business going to court, because it's not a matter of, you know, the government said and the taxpayer said. It's actually, no matter who's saying it, no matter whose story you buy, the outcome is capital, or the outcome is employee, or whatever the case may be. And that just points to the indeterminacy. Like, if people had known that up front, then somebody's made a big mistake in taking that case to court. It could be, in half the cases, it's the government. In half the cases, it's a taxpayer. We just don't have a lot of information, readily available information about how to synthesize the case law that came before. When you're using the software, you can easily just change the facts and see what happens. So if you're not sure if you're going to be able to support a particular answer as you work through and the system is querying you for the facts, you can skip that question, and basically you get to the end, you can skip a few of these questions, and it gives you an experimental sandbox where you can toggle those facts back and forth and see what happens to the likelihood of prevailing at the end. So it's actually really, really helpful for discovering the strength of your case and what it really turns on. So we've got functionality built in to address that.
Any other questions? Please.
I don't have a mic, but I think you can hear me.
I can hear you. We are, so it might be helpful to...
Yeah, my question is, I guess for anybody, but perhaps for Professor Hadfield. I have been involved doing regulatory law for quite a long time, and I've also worked in the federal government and the Treasury Board for some years. And what I've found is the regulatory agencies themselves are often, at least in the area that I've worked in, rather weak, and their staffs are often rather weak. They're of different quality. Some are very good, but some are not so good, and it depends a lot on the panel you have and so on. I find at the federal level, in the government themselves, the Privy Council, the Treasury Board, the immediate and the senior bureaucracy are usually very strong. And I find that while I haven't spent a lot of time in the private sector and in businesses, I can imagine that the private sector businesses that finance the private sector regulatory agencies that you're alluding to are strong and well financed. And so one of the questions in my mind is, how do you ensure that the agencies, the sort of people in between the government and the private sector, are strong, are well paid, and have a sort of a merit principle that is rather pervasive? Because many are political appointments, friend of a friend of a friend. Not all, some are very good, but they're very uneven. And so you get a lot of frustration on that score. I guess I'm a little old-fashioned in that I still see a distinction between the public interest and the various private interests. Mm-hmm. So that a regulatory system that's funded by private sector people alone, I don't think does the job. It's going to be, no matter how much innovation it incents, it's going to be tilted. So how do you do that? How do you strengthen the regulatory side? I mean, my field is energy, but I'm thinking that what you're talking about is telecommunications and information, and I guess that's across all sectors. But how do you strengthen that and ensure you have those kinds of people in place?
Yeah, so you've put your finger on exactly the tension we're trying to manage. How can we come up with a regulatory model that, on the one hand, attracts money and brains, good brains, to the problem of regulation, to the design of how do we keep track of the apps, for example, in any area. How do we develop better employment regulation or energy regulation? So on the one hand, how do you harness what markets do for us, which is, well, we attract people into those activities because we can pay them through a process that says, well, there's higher value to that, we'll attract you in. And I think that's really critical, because otherwise, all that brains and money is going to build that technology, which is great, but we need to keep up on the regulatory side. So I think that's critical. But the other point is exactly the one you're raising, which was how do we do that in a way that is responsive to the public interest? And that's where this model is actually proposing we need to redesign the role of government here, from moving out of the role of designing the detailed methods by which we will achieve the outcomes we want, let's say accidents in the workplace, or likelihood that your data drifts off into some use that you didn't approve of or creates risk for someone. So this model actually says we want to reorient our politically accountable bodies, our legitimacy providing bodies, to generating the outcomes that we want from regulation, and to then license those regulators according to whether or not they're achieving those outcomes. So that if I license the company that Lisa could start with her colleague in computer science, if I'm government and I license that, I say, well, you have to demonstrate to me on an annual basis, and I'm going to audit your records and so on, that you have actually caught the apps that are using third-party, violating our standards. So I want to see that you are doing that. And then it's up to her how she figures out how to do that, whether that's with rules on paper, AI, other techniques, reorganizational rules, whatever. So it's exactly that tension that we're trying to resolve. I think that's absolutely critical for us to figure out.
Okay. Well, thank you, everybody, for coming. Thank you very much to our panelists, and I hope you've had a wonderful reunion. Thank you.